Thank you very much, Antoine. Thank you for inviting me, and thank you for having me here and have this opportunity to address issues of sports and football more in particular. This is not, as Antoine said, my primary area of activity. It was not until I went to FIFA as chair of the Governance Committee. I'm a EU lawyer, EU scholar, though I've been in court too as an advocate general, and then I've been in politics. But I had never been engaged directly with sports outside the pitch that I shared with Antoine. So the only thing I actually knew and was engaged with football was by any one of us liking football and playing football. This was the first time I engaged, and successfully, I have to say now, with the governing culture of football and sports more in general, because this was nevertheless a very intensive year, a year where even if the position of chair of the Governance Committee was not a full-time position, it did occupy a lot of my time, and where I had the opportunity to engage and talk with many other people that have played a role in different positions, both in the world of football and in the world of other sports organizations. And I came out of this experience with a clear view of what are, in my view at least, the problems with the governance of sports and how can we improve it and what can we do about it. And I have to say this view is shared with many, or the majority, the overwhelming majority of my members of my colleagues, my former colleagues of the Governance Committee that left the Governance Committee when I left. And it's also shared not only with those in the world of football, but with some that I had the opportunity to discuss outside football. So the first paradox, an interesting paradox for me, even before I accepted to take position at FIFA, was this understanding that on one hand sports is probably one of the most important areas of social life that we can think about, because even if we are not directly engaged in football or sports, we like to see it, we like to play it, we get involved with it in many ways. It's certainly the most important leisure activity in society. It is one of the more important areas of societal life, and this is reflected in many ways, reflected by the fact that most of us do some kinds and practice some kind of sports, but also that, for example, the cumulative audience of a World Cup of football is said to be in the realm of around 40 billion people. And 2/3 of the world population, for example, are said to have watched at least part of the Olympic Games. This represents well the social interests raised by sports. And this social interest then has a corresponding economic impact through sports events themselves, but also through related interests such as sports broadcasting, sports merchandise, gambling, video games in many forms. It's not easy to measure the economic impact of sports-related economic activity. I've looked for it actually, and there are not many studies about it, at least at the global level, and the way it's measured, it varies and not easy to do. But we can get some indicators of that importance by the fact that it is said that it corresponds to around 2% of the world GDP, that is more than $1 trillion US dollars. And it is also revealing that some of the companies that have moved more in the top 500 list of companies of the FT are companies that are related to sports economic activities. And this is not surprising, taking into account that we are moving into a more leisure-related world, leisure-related, social and life and oriented economy. So if anything, we should expect for sport-related economic activities to become even more relevant, to have an even growing importance in terms of world GDP and economic activity in the world. Yet, and this is the big paradox, though it is such an important area of economic life and of social life, sports is regulated for the most part by private systems of governance. I would argue it's the only area of social economic life, certainly with this dimension, that is regulated by private systems of governance. These private systems of governance regulate access to the activity. You can only be a club playing in a competition and then benefiting from all the economic activities and revenues relating from that if you are accepted by that private system of governance. So they regulate the access to the market, and they define and enforce many of the rules under which those operating in that market have to act. They then, as a consequence too, ultimately control or profoundly impact on both the upstream and downstream economic activities of that market. Yet, neither is this economic and social regulation subject to the mechanisms of public participation and accountability to which all other forms of regulation tend to be. But moreover, neither are these forms of private market regulation subject to any effective form of public scrutiny or oversight. I would say that the only elements that you have had of some degree of public oversight over this activity have come from the European Union and from the application of competition rules or free movement rules. This is the only instances that you will find of that. And I'll go back at the end on why that may be and why that is also insufficient. Now, in my view, this cannot continue like this. And it cannot continue like this because my personal experience, I will not get into the details of specific cases. It's known that in the context of a parliamentary inquiry, I got into the details of specific issues. But in here, I want to talk about the systemic problems that we identified. There is, in my view, a systemic problem of governance and of rule of law. And I think it's not only with FIFA and football. From what I hear and people I have exchanged, I think this is a problem with sports in general. And in my view, that will be the second thing that I will try to argue, such systemic problem, for reasons that I will identify, will only be able to be addressed and changed from the outside. Now, this is not an indictment on everybody that works, is involved on sport, not at all. Even in my short experience, I found many people that were very good people and engaged and wanted to do the right thing. This has to do with an overall culture that is resistant to accountability, transparency, and independent scrutiny. And it basically, this overall culture and the way the decision-making processes are organized, and particularly those that are in the leadership to whom they answer, determines that independently of whatever leadership you will get, this culture will dominate and will prevail. It's not a problem with leadership. It is not a problem that you will solve with leadership, because whatever leadership will actually try to change this culture will be removed. Now, in the context of a culture that does not accept independent scrutiny, transparency, accountability, it's not surprising for cases like those that we've heard of corruption to emerge. But in fact, that culture makes it more likely for those cases to emerge, and also makes it harder for those cases to be identified and pursued. But, and this is my crucial point, football governance issues do not limit themselves to those instances of criminal corruption that you can find through the criminal legal system. those are only the ultimate instance of the reflection of a much more deeply embedded governance problem. And so we really need to address that governance problem. The creation of the Governance and Review Committee in FIFA, and that's the experience I personally had, was followed the scandals that I think you all know arise recently in the recent years at FIFA. And the role of this Governance and Review Committee, that was a new committee set up in the context of the reforms undertaking following those scandals, and particularly, and this is an important point, not simply the scandals, because the scandals had been around for many years, but the fact that the scandals finally led to judicial action on the part of judicial, in particular American criminal authorities. It is an important point that it identifies the systemic problem that I mentioned, that there was only action when finally the scandals that had been discussed and talked about for many years led to specific criminal indictments and actions on the part of judicial authorities. But those actions led, therefore, to a set of reforms to be adopted by FIFA. And one of the elements of those reforms was precisely the creation of this Governance and Review Committee that I chaired. The Governance and Review Committee had, and still has, at least in the rules, we always say there's law in the books and law in actions. Antoine knows this. It's a thing we used to say almost every day at the European University Institute. In terms of the rules, the Governance Committee of FIFA basically has three kinds of competences of powers. One is that of monitoring reforms, the governance reforms that had been adopted. The second one was that of enforcing some of those reforms where those reforms were reflected in particular rules. And that had mostly two areas of activity where the governance and the review committee had enforcement powers. Eligibility and admissibility of candidates for FIFA committees and FIFA Council on one hand, and supervision of elections on the other. And I will talk about this too in a minute. And the third competence granted to the Governance and Review Committee was that of proposing new amendments to the governance regulations of FIFA and proposing new regulations too. So, in my view, when I looked at the rules, it was the first committee that has the formal right given in the FIFA governance rules of proposing amendment to the rules and proposing new rules. And the committee did propose some rules, and I will also talk to you about that in a minute. So in light of these competences, what did the Governance Committee, what did we do in the short period that we have of competences, of exercise of functions? Because I was around 10 months between the moment I was elected and formally entered into functions. And the Governance Committee itself, we had only 3 members for a certain period of time, so we could work as a review committee but not as a full governance committee. And it was only in January that we could start working as a full governance committee. So as a full governance committee, we had around 5 months of activity, very short period of time, in which nevertheless we did adopt some important decisions, maybe some of them actually responsible for our ultimate downfall in the position. So the first function we had was the eligibility and admissibility checks that were introduced. This was basically a control on whether people could be appointed to certain committees of FIFA or whether people could be candidates to the FIFA Council. So both a control on appointment on positions to which you are appointed or control for positions to which you are elected. The way we interpret the rules, and the rules are not absolutely clear in that respect, but the way we interpret the rules was that the eligibility, that is appointed positions for committees, was to be done only by the review committee. That's clear for the rules, from the rules. But the admissibility to the elections, that was a decision to be taken not only by the review committee, but by the entire Governance Committee, following the eligibility test conducted by the Review Committee. So with respect to the admissibility to the elections, there is a rule on the basis of which we interpret that the entire Governance Committee had a position. But by the way, in agreement with the members of the Governance Committee, because the Governance Committee has to have at least half of its members are independent, and during the time I was chair, more than half were independent. And I agreed with those that were not independent and were members of federations and either could vote for the elections or run for the elections, that they will recuse themselves from participation on these decisions on admissibilities, and they did. So de facto, the decisions on admissibility were taken by the Governance Committee only in its independent composition, if you want. How did we conducted these checks? Because this was a new thing. Well, not totally new, because it had been conducted on an ad hoc basis for the presidents of FIFA that led to the election of Mr. Infantino. And it had been conducted at the time because there was no Governance and Review Committee, it was conducted at the time by the Audit and Compliance Committee chaired by Mr. Scala, then chaired by Mr. Scala. When we arrived, we decided we wanted a procedure, and the procedure included something that was in the rules already. So the candidates have to fill in a questionnaire where they might identify, for example, whether they've had previous convictions or have ongoing procedures, criminal or civil, against them. Then there's also an integrity report that is done by an investigative company. The candidates themselves have to make available all kinds of information that may be required from them, and in many instances, when that integrity report will raise some questions, we will then ask the candidate to reply to the issues and possible suspicions or allegations that arise from the report, and on the basis of that request information. And this, let me tell you, was already one of the reasons why we started to have a kind of a tension with many leaders of confederations and federations. The simple fact that we will ask for information and questions on suspicious situations was very badly accepted, and this was transmitted and conveyed to us in different ways. We did not, however, have investigatory powers, so we could not. So we depended on the cooperation of the candidates, and we depended on the integrity report and the questionnaire. And the integrity report basically was based on public information. And this public information, by the way, varies between states. So in some states, the investigatory company has access to judicial databases of cases. In other cases, in other countries, it doesn't have. This is one of the problems. It varies the extent of the integrity report to which could be undertook. Now, the scope of the text itself is not at all clear in the rules. The rules say there is this report, this test, this eligibility check, but it doesn't say exactly what it should look like, what it should include, and what is the standards and the criteria. As a way of providing both more transparency on our role and certainty to the candidates, we decided to adopt and to publish informative notes with the criteria that will be developed, we were developing in our decisions. So if you go to the FIFA site, at least you have two notes until I left the Governance Committee. You have two notes. You have a first note, and then you have a second note, one from December and the second one in March, with the criteria that we had developed as an informative note, something similar to what the European Court of Justice does to national courts, actually, that with the criteria that have been developed on a variety of issues. And what were those main issues? And if you go and see the informative note, you will see those main issues. Had to do with questions of integrity, in particular judicial proceedings or allegations about certain integrity issues regarding the candidates, conflicts of interest, and then different matters of compatibility with FIFA rules, particularly its code of ethics. Let me give you just some of examples of some of the harder issues, some of the harder questions we had to address. The first one regarded past criminal convictions and disciplinary sanctions pronounced against the candidates. And in this respect, we took into account both the nature of the charge and the sanction imposed. So, to give you one example, it is different if someone has been convicted, even criminally convicted, on the basis because of a financial crime, or if that person, and this may happen in some states, had a past criminal conviction, for example, for reasons of actually having used freedom of expression. Should we take the two in the same? We didn't. So it was clear to us that if you had been convicted for a financial fraud, for example, you will be out. But if the conviction was a conviction that was, for example, related to something that in another state could be seen as an abuse of a fundamental right, then we would have to take that into account. And the person, someone should not be excluded for reasons of having used its freedom of expression in that particular country that could lead to a particular criminal indictment. This was one aspect. The other one had to do with the severity of the sanction, whether the person had an actual sanction imposed on them or the misdemeanor, only a warning, particularly in terms of the disciplinary proceedings. This was very relevant. Now, this was not deprived of problems. One problem that we face, I'm going to be transparent, though I'm not going to talk about the specific cases for obvious reasons, is that we have past cases where people had been the object of sanctions by the ethics committee of FIFA, not the ethics committee, the one that ended in May, but with an earlier composition, where the people that in cases that seem clear cases of corruption, and that later had been addressed as corruption, but they had been convicted only of lack of information by not having disclosed the money that they had received. So the information for the case for us will tell us that there was probably something serious going on with that person. But on the other hand, there had been an assessment of that specific case done by the FIFA Ethics Committee years before, saying this is a misdemeanor. The only problem in here is that the person did not communicate that he or she received money from one candidate. So what do you do in that case? We decided to have an approach that was, if the only thing we had was the decision of the Ethics Committee, moreover, then we had to stand by the decision of the Ethics Committee, and that was it. But if we were able to ascertain the same facts independently, and through the same facts independently we'll find out, and we found out in some cases surprisingly, because we will ask the candidates and they will say, yes, I received the money, then we were able to declare that person not eligible. That was the approach we followed. Another very hard and difficult case we had regarded instances where what existed was only allegations or ongoing proceedings against the candidates. And these are indeed difficult cases, particularly when you have ongoing proceedings. Because on the one hand you have the presumption of innocence of those involved. And you have to take into account that by excluding that person, you might be affecting the rights of that person that at a later stage may actually be absolved of that case, may not come to be convicted. And moreover, what cannot exclude, and in fact there were instances where I realized that was taking place, particularly when we were talking about allegations and not necessarily ongoing proceedings, where allegations emerged just before the elections regarding some candidates. And so there could be an attempt to smear a candidate and to be something not more than that. On the other hand, eligibility and integrity checks are not, and even the CAS has made that clear, are not a judicial assessment of guilt. They are not a subjective assessment of that person. They have a function and an objective that is that of protecting the public credibility and trust in that instance on FIFA. And that may require to exclude candidates even if their guilt has not been confirmed by a court of law or by a disciplinary body. Might require to exclude those candidates at an earlier stage. In fact, if this was not so, then the integrity check will have a very limited useful effect, because then what you will need is a rule saying, well, either the person has been convicted or has not been convicted, and if it has been convicted, whether either the sanction includes an exclusion from running to positions on sport, or it doesn't include. This is an alternative system. It would be possible to have this system, to say you are allowed to be a candidate so long as you have not been convicted, and part of the sanction of that conviction has been to exclude you from running in the future for such positions. By having an integrity check, that is, you are, and FIFA, that was our interpretation, was adopting a different approach. And it made sense in light of the objective and the necessity for FIFA at this stage to regain public trust and credibility. And so what we decided was that we were going to make a difference between the cases where there were only allegations or even ongoing proceedings, and the cases where, even if there was no conviction, there were already formal charges brought against the person, or at least provisional judicial measures. In those cases, we believe there is already a prima facie a decision taken by a public authority that at least creates a cloud of suspicion that does not make it positive for FIFA to allow such person to run or be in certain positions. This is the balance we achieved between protecting on the one hand the presumption of innocence and on the other hand protecting the credibility and public authority of FIFA. So the difference between cases of simple allegations or cases where at least some assessment had been made in the form of formal charges being brought by criminal authorities or judicial provisional measures, for example, being taken. A third issue that was very present was questions of conflicts of interest. We exclude people in cases that had not even led yet to decisions by the Ethics Committee, but where the information that we had on the basis of the cooperation we had with the Ethics Committee, so we will always ask the Ethics Committee if there were any ongoing proceedings with respect to candidates. And they will, on a confidential basis, because we were both required to protect the confidentiality, and the candidates were aware of this, they will send us the files that they will have on ongoing proceedings. So in some cases, even in cases where they had not reached a final decision, the information they had was already enough for us to say, well, one thing is if the person has or not a violation of the ethics rules as determined by the Ethics Committee and what will be the sanction for that, but it is clear at least that the person has not acted to prevent a material conflict of interest. And there were some cases of this type, and these persons were excluded. By the way, there were other cases regarding the previous point where we had allegations but no formal charges, and because we did not have investigatory powers but the Ethics Committee had, what we will do is that we will forward that information to the Ethics Committee. So there were several cases of people that we declare eligible because we had nothing more than allegations and some smoke, in some cases a lot of smoke, but not more than smoke, and we will forward the information to the Ethics Committee for the Ethics Committee to pursue the investigation. Another problem we detected was that aside from material conflicts of interest in the past that led us to exclude persons, there were several instances of potential conflicts of interest. And in my view, this is one of a serious problem that exists. Now, the new FIFA rules foresee third-party declarations of interest by council members, but only by council members. And by the way, these declarations, these third-party declarations are sent to the review committee, but unfortunately we only got it by the moment I left my function. So it took us a long time to be able to gather this. We were patient. We decided not to give the members several times, but it took us a long time to get this third-party declaration. So I had no possibility to make an analysis of whether or not the risks of conflicts are widespread. But what we did do is that we believe that the risks of conflict of interest, of potential conflict of interest, are certainly not limited to the Council. Exists in other areas and need to be pursued and prevented in other areas. Let me give you an example. The Development Committee. It's one of the most important. It has a huge budget to distribute. It distributes money to the assistance on football. And there is no instrument, nothing in the rules, aside from the general ethics rules, but there's no mechanism to guarantee, to have transparency, to somehow require some disclosure of interests of the member of that development committee. And the risks are very high because by definition, many of the people that go to the development committee are involved on football activities. So this was one of the first things I detected, and I proposed to my colleagues, and we adopted a rule whereby we would only, in cases, because at the same time, people that go to the development committee, it's not a full-time position, and they, by definition, come from football. So you cannot simply say, well, if you are related with football, you cannot sit in the development committee because you have a potential conflict of interest. So we cannot exclude it by that. So what we came was with this rule requiring everybody that will sit on the development committee and some other committees to disclose their interests in football to the chair of the ethics committee and the chair of the development committee. So to require them that. We had different people. Some of them, one particular case, did not accept to do it, and he was not declared eligible, for example. But most did accept to do it, and they disclosed. So it was a first step in that direction. But because we wanted this to become a formal rule and a more widespread obligation, this was actually one of the proposals that the Governance Committee made in this short period of life to the Council for decision by the Council in its meeting before the Bahrain Congress. And among the proposals we sent for that meeting was the proposal of a general obligation of disclosure of interests for all committee members. And unfortunately, this rule and this proposal of the Governance Committee was not adopted. A fourth and final issue in terms of eligibility and disability that led to a lot of contested and difficult decisions and regarded political neutrality and prevention of any form of government interference. Now, Article 14 of the Code of Ethics of FIFA requires FIFA officials, and I'm citing here, to remain politically neutral in dealings with government institutions. Now, the view of the Governance Committee was that there was a clear structural incompatibility resulting from this rule between being a member of a government and this neutrality required by Article 14. But by definition, how can a government member be neutral with respect to his or her government? They cannot. And yet this had been the practice many years at FIFA, and it remains the practice in many confederations and federations. And I will address that in a moment. Now, the committee did consider the possibility, what if there's simply an obligation for that FIFA official or FIFA council member to recuse himself or herself from any decision affecting his or her country? Will that be a possible solution for that? We thought about that, but it's clear for us that the political interests of a government are not restricted to matters directly dealing with their country. There are many matters that dealing with other countries whose interests are parallel to those of the government of that state. And there are others where there may be opposing interests. Moreover, having a government minister that is at the same time a FIFA official can additionally both directly affect the relations between FIFA and that state. And we had the case that, if anything, the importance and the public relevance that it result and the discussions on that we had to suffer in that respect highlighted was precisely that the fact that someone is a member of government, for example, makes that case a much more important case, a much more sensitive case than otherwise will not. So if anything, that's a confirmation of the fact, of the reason why someone should not be a government official and in the FIFA Council member. But in addition, the fact that someone is in a government and in a FIFA Council position risks entangling FIFA in controversies associated with the government of that state. And moreover, and final point and final reason, imagine that because if we say that you allow it for someone coming from one state that is a government minister, then you have to allow it in all cases. So you could get the absurd that the FIFA Council could in fact become an intergovernmental organization. And for us it is, I have to say, it was very difficult for me to accept how could FIFA in the past, for example, in the cases of some states, if the government minister sends a letter to the federation asking them to do something, that football association is suspended because there's government interference. If that same minister, instead of sending a letter, becomes the president of the federation, there's no problem whatsoever. This is completely absurd and it makes no sense. And only a culture that is a culture that is selective on the application of the rules could accept this to go on. Now, by the way, the Governance Committee also considered that other political positions, not only government positions, might be in conflict with this rule. We decided, precisely because we knew the sensitivity of this issue, to apply it progressively. So we said government positions is clear because the text of the rule itself talks about government organizations. So government organizations is the minimum. But we, in our decision, said that we did not exclude it from the future to include other political positions from this prohibition too. Very important point. Article 14 is applicable not only to FIFA officials but to football officials in general. So the Governance Committee only has jurisdiction to decide on the eligibility and admissibility for FIFA positions. So we could not prevent, we had no direct competence to prevent people from being in elected to a football association or confederation. But our interpretation of the rule is that equally valuable for those positions, because they are in contravention of the ethics rules. And in my view, the Ethics Committee should act in that respect. We will see what will happen, but so far nothing has happened in that respect aside from our decision. With one caveat, it is that the Governance Committee have actually been requested by a football association whether that it was applicable to the position of president of a football association, and the Governance Committee there said, well, we have no direct competence to decide on the eligibility of candidates for football for national associations, but our interpretation of the rule and that we are applying is that it is incompatible. So that is our recommendation. Another main, I'll need 5-10 minutes more and then I can conclude. Another main competence that we have, and very important in my view for the future, is that of the supervision of elections. So Articles 62 and 75 established for the first time that the elections shall be monitored by persons appointed by the Governance Committee. And these are elections to the FIFA Council, as well as elections then, and there the rules are more detailed, for the presidency of FIFA. Even if in this case there is the possibility for the Council to appoint an ad hoc electoral committee that will replace the Governance Committee in supervising the elections for president of FIFA. Now, we heard, both through the knowledge that we had of under the eligibility and admissibility, and there many of people that we excluded had been involved in cases of improper behavior in the electoral context. But in addition to that, we had from several senior FIFA officials many several information regarding risks to the integrity of the electoral processes, particularly at the level of confederations on the election for FIFA Council. And so we decided, even if we had only 4 or 5 months, I asked Professor Joseph Weiler from NYU, that was a member of the governance committee that also left, but had come in and to, in a very short period of time, 1 month and a half, to adopt 2 sets of guidelines on issues that were immediately on our table and for me were very urgent because we had several confederation elections taking place. One, and we had a team supervised by him that adopted that, and then the governance committee revised those 2 documents, and those were the 2 initial documents that guided our action in terms of supervision elections. One was a guidelines on the electoral procedures, requiring different matters to answer to risks that had been identified to the integrity of the electoral process. Things such as preventing people from taking cameras to voting booths. It's a usual way of controlling votes. So it was difficult for someone supervising elections to prevent corruption and vote buying. That's difficult. But at least you can limit the effects of that by limiting the instruments of voting control, and so or other forms of voting fraud. So we prevented the use of cameras. We required particular pens that were given by our monitors to those voting, because that's a usual way of controlling the vote, by the color of pens. We acted with respect to the voting bulletins. They half an hour before the elections they had to be signed by our representative, so as to prevent the risk of voting bulletins that had been copied and duplicated, because candidates that were not members of the incumbent president always fear that the administration was in the hands of the incumbent president, and therefore that they could have a copy of bulletins. There was a variety of instances, and we have a very detailed set of rules that now, I don't know the extent to which it continues or will continue to be enforced, but there's a very detailed set of guidelines on electoral procedures that was adopted to prevent that. And there too, let me tell you that the reactions we got say a lot about the dominant culture, because when our rules were aimed at protecting the integrity and limiting the powers of the incumbents, those that opposed the incumbents were very happy and were actually eager to have us act and say, you should intervene, you need to guarantee the integrity of the elections. But when the decisions will go against their interests, then it will come the argument, you cannot interfere with the autonomy of the Confederation, this is the democracy of the Confederation. And we said, what we want is to protect the democracy. We are only exercising our roles of supervising the elections. We're not interfering with the elections. There's a power, but there was this ambiguity and this duplicity of discourse was permanently there, and was astonishing for me to see sometimes the same persons, I'm not going to say who, but the same persons one day will tell us, oh, you must do something, you must act, you must intervene, and then some weeks later in another election where they had a different interest, oh, you cannot intervene, you have to protect the autonomy of the Confederation because it's a principle of FIFA. And this says the extent of the malaise that there is in this governance culture. Now, another issue, and it is very representative of the culture that we have, regarded female representation. And this was, I think, one main issue and one of the main reasons why I think many people talk about other cases. I think this case was one of, probably, it's less talked about, but it was an issue that in my view is very much responsible for the fact that I at least am no longer chair of the governance committee. FIFA adopted a rule saying that at least that the confederations in the representatives that they elect for FIFA Council, at least one of them needs to be a woman. That's what says the rule. It's to promote and favor female representation. It was one of the reforms adopted was at least one of those elected need to be a woman. Now, I get the initial set of procedures of different confederations that were preparing their elections, and when I see them, I almost couldn't believe, because several of them, 4 confederations to be exact, had interpreted that rule and that implemented that rule by creating what they called the female position. So they had five positions for candidates. They created a female position, and all women candidates were candidates to that single female position. So they had transformed the at least one woman in not more than one woman. They transformed a rule that was aimed and intended to favor and further female representation in a rule that was limiting female representation and discriminating against women. And I immediately wrote a letter to these several confederations saying this cannot be changed. And to be honest, all confederations changed except one. One confederation, I will say it because we actually sent a letter to them at a second stage, because then they reformed the rules but they continued to be incompatible. And we sent another letter and we requested from them for the letter to be public and notify to the female candidates, what they never did. So the female candidates, because we said the female candidates need to be notified of them, so that if they could exercise their rights, and they never did. But because we required the letter to be public, I have no problem in naming this confederation was AFC, the Asian Confederation. They continued to discriminate against women. So to transform the rule that was aimed at favoring and promoting female discrimination in a rule discriminating against women. But the extraordinary thing is that was the opposition and the refusal to change the rule. And claiming even that we were the ones that were interfering with their autonomy and their democracy. Now, the last competence that the Governance Committee had was that of proposing new reforms and amendments of rules, as I said. And we did do so. So in the beginning, when the full Governance Committee was not composed, I remember I suggested to the President, and I know at least one of these issues went to the Council, was discussed, that it was important, for example, to have non-renewable terms to the members of the independent committees. I believe that if there was no a single non-renewable terms, it could happen. Actually, what happened? That is that then you are replaced if they are not happy with your independent decisions. The second aspect I proposed, and to my knowledge, I was informed it was discussed in the Council but not agreed, was to have cooling off period, at least for the members of independent committees. That is, that you should not be allowed to have engaged in contracts, and that included people like myself, with FIFA after you leave your functions for a certain period of time, for 2 years. Because that's another constraint on your independence. It's not only the fact that you are subject to renewal, it's the fact that you know that if, depending on how much they will be happy with your work, and the happy there, it might not be with the quality of your work, but of your independent positions, and that's the problem. That's why you need to safeguard independence. Then the problem is that if you have the prospect of working afterward for a certain period of time, that is a potential condition and limit to your independence. But I was not successful with that too. The Governance Committee then made a series of additional proposals, formal proposals, to the Council. To be decided in the Council meeting in Bahrain too, and to my knowledge, as you know I left at the time, they were not adopted with one exception. One of them was to reinforce the independence criteria, in particular for judicial bodies. In my view, I think that for some of the standing committees, I don't see so many need to have the independent positions that are called independent positions there. And even that kind of independence criteria, but it was much more important for me that for the genuinely independent committees and judicial and quasi-judicial bodies, that the independence criteria needed to be strengthened. One of the paradoxes is that for the appeals committee or for the ethics committee, only the president, only the chair and deputy chair need to be independent. The other members are not independent. So you have a majority that are not independent. And this is a problem that you have. And so we wanted to reinforce that. We also propose actually that for less important committees, the eligibility checks could be done at the level of the confederations, but with one condition. And this was what we actually intended to do, was that the confederations needed to introduce their own independent bodies. to conduct, they needed to do their own eligibility and admissibility checks for their federations and the confederations themselves. And the independence of these bodies at the level of the confederations and the criteria to be applied with them will have to be reviewed by the governance committee. So basically what we were doing is giving some power to the confederations to do some of the eligibility checks, but in exchange of these confederations having their own independent bodies and performing this own criteria. So as a way of introducing the same instruments of good governance at the level of confederations and federations. Because the problem is that if the basis is not embedded in this culture, then it doesn't matter what the leadership thinks really in a system such as that of FIFA. We also propose to extend disclosure of interest, as I told you, and we propose a FIFA human rights policy, and that was something that indeed was adopted. It was our only formal proposal that was adopted. In addition to that, we had two other issues in our agenda that we never get to intervene. One was the regulating election campaign. Our initial priority was the integrity of the electoral procedure, because we had confederation elections at our door a few weeks after the full governance committee was composed. But we wanted for the future to regulate campaign financing and how electoral campaigns take place for FIFA Council and FIFA Presidency. To give you an example, if you want to run for the presidency of FIFA, it will cost you certainly more than €1 million, likely much more than that, just in terms of the campaign of traveling all around the world and visiting all the football associations. If I ask you, how is that funded? How do candidates fund that? Where does that money come from? No one knows. And this is a major issue, and this needs to be regulated too. Now, both the reaction to our decisions made this clear to us that when we did try to be progressive, we did try to be diplomatic in the way that we framed our decisions, but we knew that there was a lot of resistance. But we expected, and that was our surprise, we expected that in light of the credibility challenge that FIFA had, that we would have had the support to have the time to change this culture, to resist to the pressures, to resist and have the time to change this culture. Instead, we did not have, and as you know, in the Bahrain Congress, what you had was that both me and the chairs of the Ethics Committee, we basically were removed from positions, and then most of my colleagues of the Governance Committee left the Governance Committee in protest too. And this is enough for you to think about how systemic this governance problem is, because what happened in Bahrain is parallel to the same thing as you waking up one day in your state and reading the newspaper, opening the television, and seeing that in that morning the President of the Supreme Court, the Attorney General, the Constitutional Court, the Central Bank, they've all been removed from their positions. And in some cases, in my case, after 10 months in function, you would expect that in order to take such a drastic decision, with the potential sign that it sends of condition and limiting the independence of these bodies, that very serious reasons will have been put forward. None. And ultimately, what this tells you is that the leadership of FIFA and of sports organization, and this is the fundamental problem, is not accountable and does not answer to public opinion or to public scrutiny. They answer to a small set of actors. And if they don't do what that set of actors wants, that's their own political survival that is in question. I have no doubt that if I had and my colleagues had not left, probably then it would have been the political leadership of FIFA that would have left. And this is the reason why, in my view, change can only be imposed from the outside. Now, at the origin of this is the fact that participation in football is a closed shop with a limited set of actors that control the process for a long time and control the votes. At its worst, is, and we know that today, by different cases, you have instances of vote buying. But in other cases, when you don't have vote buying, you have voting syndicates. And basically, to enter into this, it's very difficult. Just I challenge most of you that have not been part of the system to try and go and run for an election for a federation or for a confederation. It's a closed shop. And so even if you have instances with the American criminal procedures where basically through the action of the American criminal authorities, some bad apples were taken out of the trees that produce the apples, the system that produces apples still remains in place. It's still the same. It's still the same community, it's still the same rules, and they answer to the same things. That was what made it possible for so many years to have the scandals, for everybody to know about the scandals. And I ask you, what had happened until American judicial agents enter into hotels and detain people? Nothing. And it will be the same for the future. Nothing will happen because the leadership does not answer to that. Answer to a set of people that are the same and do not want accountability, do not want independent scrutiny. Now, just to give you even one important point and one element of it, I mean, even the Governance Committee that was supposed to be monitoring now and implementing reforms is currently not in conformity with the rules. The Governance Committee is supposed to have half of its members independent. Now it has less than half of its members independent. What happens? Nothing. It continues. In theory, since the Governance Committee is not acting and doesn't have a composition in light of FIFA rules, it should not be in a position to supervise elections. Elections should not be taking place. Everything continues as if nothing happens. Now, in my view, this problem is not unique to FIFA. It exists for other sports confederations. And that's why, in my view, we need external action, and only through external action you will be able to impose some degree of scrutiny and oversight on the governance of these transnational sports organizations. My proposal will be to create an independent international agency. This independent international agency should not govern sport, should instead assess and supervise the compatibility and the conformity of those sports transnational organizations with fundamental good governance principles, basically ethical questions and the integrity of electoral procedures. Only those two aspects. There's no reason why these entities should be in a position to control access to the market, to have regulatory powers over certain areas of the market and social life, and they'll be subject to no control whatsoever, no accountability, no scrutiny whatsoever on those fundamental aspects of good governance. And this cannot be done at the level of an individual state. Switzerland cannot do it for one simple reason: they have no bargaining power. That's the reason why only the European Court of Justice was the only judicial body that was able to bring under some degree of scrutiny the sports associations. Why? It was the only time that FIFA and UEFA accepted to even go to court and litigate. Why? Because they could not say to the European Court of Justice and the European Union, if you don't respect our autonomy, we exclude England, France, Germany, Italy, Spain. I always say to my students, it's an example of how the European Union in some areas can reinstate public control and public sovereignty over areas that are no longer controllable by individual states. So in my view, only the European Union actually can take the initiative to promote such an independent agency, even if it may be an independent agency to open then to other states. And with the basic argument, you want to act in our internal market, you want to filter and determine access to our market in that economic activity, you want to regulate that market, well, if you want to do that, you have to conform with this basic set of values. And we have this independent agency to regulate this, as we have independent agencies in other areas. As simply as that. I believe that if we don't act this way, reform, for the reasons that I said, will not come from within. Thank you very much.